Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. What the arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, what your rights are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your most serious type of offenses, whereas your misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. When I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided in 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. A person is convicted of a second degree felony. The range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type punishments. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only, and the fine cannot exceed $500. Now, if a person is convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, if a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is 1 year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. Now, with unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete that probation, the case will be dismissed, and you may qualify for what is called a non-disclosure. And what a non-disclosure is, your record is sealed to the general public. So the general public cannot have access to your record if you have a non-disclosure on your case. Now, the other type of probation is called adjudicated probation. With adjudicated probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, which means that the judge or the court can set aside your conviction. You will no longer have a conviction. And in order to qualify, 3 things has to happen. 1, you have to successfully complete the probation. 2, there cannot be any more time left on the probation. And 3, you have to be successfully discharged off of the probation by the probation office. If those 3 things happen, then the court has the discretion to set aside your conviction, and you will no longer have that conviction on your record. Now, if you get a subsequent conviction, or if you get another conviction later on, in the case that you receive judicial clemency on, can be resurrected, brought back up, revived, and it can be used against you. And if you try to get a license with Child Protective Services, which is CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. Now, everyone here for arraignment should have a clipboard. And I'm getting ready to go over the information that's on that clipboard. Now, the first document that I'm going to go over is titled Judge's Explanation of Rights to Defendants Without Attorney. It should be the first document. And on that document, it states that as a defendant in a criminal case, you have three options. That's three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request, if you cannot afford to hire an attorney, you may request that an attorney be appointed by the court to represent you. Or number three, you may represent yourself. That is, you can, if you waive or give up the right to have an attorney, you can represent yourself. Now, that first paragraph states that if you want an attorney, you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. All right. The second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Okay, but you must first sign a waiver of your right to have an attorney. Now, there is a 3-page document that is on that clipboard, and that document is titled Jefferson County Affidavit of Energy. You can just turn to that right quick, and then we're going to come back to the judge's explanation. That 3-page document, yes, it looks like this. Okay. Now, if you want to apply for a court-appointed attorney, it looks like that. If you would like to apply for a court-appointed attorney, you will have to fill out the first page of that document. And then on the second page, at the top, it says defendant's oath. You would have to fill out that top portion on the second page. Okay? And you will fill out the portion that says unsworn declaration by defendant, which is kind of toward the bottom of that second page. Should have some little brackets around it. Those are the only two things you would have to fill out on the second page. You fill out the whole first page and the two sections on the second page, and then you stop. Okay, now let's go back to that first page I was going over, which is the judge's explanation of rights to defendants without attorney. I went over the second paragraph. The third paragraph says that you cannot speak to the attorney. Now you cannot speak to the prosecutors. We have prosecutors, the assistant criminal district attorney, works for the Jefferson County District Attorney's Office. If you represent yourself, that means you are your own lawyer, and you will have an opportunity to talk to one of the prosecutors to see if you can work out a settlement. We call that a plea bargain, a settlement on your case. Okay, but you cannot talk to them unless you first sign the waiver. There's another document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You can just turn to that page. That's for individuals who wants to represent themselves. If you want to represent yourself, you'll fill that out. If you don't want to represent yourself, you don't fill that out. All right. Now, let's go back to the judge's explanation. Okay, now, there's a second to the last paragraph. It said block. It states, be aware that there are dangers and disadvantages of self-representation. Waive your right for an attorney, waive your right to an attorney, and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Okay? Now, if you choose to represent yourself, that's the last paragraph before we get to the bottom. If you choose to represent yourself, you may change your mind at any time. let's say you decided to represent yourself. You talk to the prosecutor. Trying to work out a plea bargain agreement, they like what they are. And you say, well, judge, I want to represent myself, you can change your mind, you could tell the judge, well, I want to apply for a court-appointed attorney, you can do that. Okay, so you may change your mind at any time. All right, now, at the bottom of that document. Yes,
If I do that, I decided I really don't want that, represent myself, so I have time to get my own attorney.
yeah, you can do that too. Yeah. Okay, now, at the bottom of that document, in bold letters, it says defendant's choice. Mark initials next to only one choice. If your choice is to hire an attorney, if you want to hire an attorney, you will place your initials on the first line at the bottom to the left. Now, if you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. Okay? Now, if you would like to represent yourself, that means waive your right to an attorney, then you will place your initials on the fifth line to the left. Okay, so everybody should be able to put their initials on one of the three lines. And whether or not you want to hire an attorney, whether or not you want to apply for a court-appointed attorney, or whether or not you want to represent yourself. And then once you place your initials on one of those lines, then you will sign your name at the bottom where it says defendant, and you will date it today's date, May 6th of 2025. Yes.
If, I wanted to sit by my sister in just a second, but, can she sign up for like a public defender now, but in the future possibly hire her own?
That's what that last paragraph
Okay,
says.
I just want to.
You can change your mind. I think he asked that question. No, he asked that question.
Okay. good.
Yeah,
I just-
okay. Any questions? Any questions? So just a brief recap. If you would like to hire your own attorney, place your initials on the first line to the left. If you would like to apply for a court-appointed attorney, place your initials on the third line to the left. If you would like to represent yourself, place your initials on the fifth line to the left. Okay, now, brief recap. If you are hiring your own attorney, you only need to sign one document. And that's the judge's explanation. Everybody's gonna sign that. But if you are hiring your own attorney, that's the only document that you will sign. Because you will say, place your initials on the first line, sign, and that's it. If you would like to apply for a court-appointed attorney, the two documents, you're gonna sign the judge's explanation, the initials on the third line, and the signature. And then you will fill out the Jefferson County affidavit of indigence. Fill out the first page, top of second page, which says defendant's oath, and the middle of the second page that says unsworn declaration by defendant and you stop. If you like to waive your right to attorney, that means you would like to represent yourself. On the judge's explanation, you place your initials on the fifth line to the left, sign the bottom, and then you will fill out a document. Read and fill out a document that is titled waiver counsel for purposes of a guilty plea or proceeding to trial, and then you stop. Okay? So you hire an attorney, you only sign one document. You know, that's the document you put your initials in, that's it. You don't have to do nothing else. If you are applying for a court-appointed attorney, you sign the judge's explanation and then that affidavit of indigence. Fill out the first page, top of the second page, and the middle part of the second page. And if you would like to, and then you stop. If you like to represent yourself, you're gonna sign the judge's explanation, put your initials on the fifth line, sign it and date it, and then you'll sign the document that's titled waiver counsel for purposes of entering the guilty plea or proceeding to trial. All right. Any questions? Okay, now, as a defendant in a criminal case, as I mentioned to you earlier, you have rights. Another right that you have, if you decide, well, the other right that you have is you have a right to have a jury trial. That area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. listen to the arguments of the attorneys. They will, deliberate, and then they will decide to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. In essence, if you do not want to have a trial by jury, that is, you have a trial by jury when you enter a plea of not guilty. When you say, I'm not guilty of these charges, I want a trial. All right? Now, if you, but when you enter a plea of not guilty, saying I didn't commit the offense that I've been charged with. You can also enter a plea of either guilty or no contest. If you enter a plea of guilty, you're telling the court that you committed the offense that you were charged with. Or if you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charge. Now, if you enter a plea of guilty or no contest, that tells the court that you would like to work out a plea bargain. Or you would like to, if you enter a plea of not guilty, let me get back to not guilty. Not only do you have a right to have a jury trial, you might say, well, I don't want a jury trial. I want the judge to decide. In essence, I want the judge to be the judge and the jury. We call that a bench trial. You have a right to have a bench trial. Now, the judge will listen to the evidence, the judge will listen to the arguments of the lawyers, and the judge will apply the facts to the law, and then make a decision as to find you not guilty or guilty. Now, if you are entering a plea of guilty or no contest, then you have a right to have what is called a plea bargain. That is, you have a right to negotiate with the district attorney's office to see if you can work your case out. Or if you have a lawyer, your lawyer can do that. We call that a plea bargain. Now, if you come to an agreement, we call that an agreed plea bargain. In essence, let's say the state offered to give you deferred probation. You say, I want to take that. And then y'all have an agreement. Then it comes before the judge, and the judge can do one or two things. The judge can accept or reject the plea bargain agreement. If the judge accepts the plea bargain agreement, and if you decide like within 30 days that you would like to have a new trial, or you would like to appeal your case, that is, you want to have a higher court to look at your case to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you, you have to get permission from the judge. If you follow the plea bargain agreement and you want to appeal, you have to get permission from the judge. The judge gives you that permission, then your case is going to leave this court and it's going to go to the 9th Court of Appeals, which is right upstairs above us. 4 judges up there, they will review your case and they will decide whether to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court in order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the 9th Court of Appeals. You can appeal it to the Texas Criminal Court, which is the highest criminal court in the state of Texas. It's the Texas Court of Criminal Appeals. And it is located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. I will explain it to you. Pro se means you represent yourself, you by yourself. And you're petitioning that court to review your case to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you or committed an error by convicting you. They can do one or two things. They can either grant or deny your petition. If they grant your petition, they can simply find you not guilty. Case over. Or they can send the case back upstairs to the 9th Court of Appeals with orders, or they can send it down here with orders. Give you a whole new trial. If they deny your pro se petition, then at that point your conviction stands. All right. Now, the other type of plea bargain that you have a right to have is called an unagreed plea bargain. For example, let's say you in the state of talk, they offering you 80 days in jail or something. And you say, well, I don't want to take no 80 days in jail. I want to see if I can get probation. So you don't have an agreement. I want the judge to decide. So the judge decides what the punishment is when it's unagreed. Okay, we call that an unagreed plea bargain. The judge can give you punishment anywhere within the punishment range, or fine anywhere within the punishment range, jail time or probation. All right. Now, You also have a right to have witnesses to come to court. Witnesses sit in that chair that has the microphone in front of it. We call that the witness stand. And what witnesses do, they can testify for you or against you. If you represent yourself, you can ask some questions. If you have a lawyer, your attorney can ask some questions. We call that either direct examination or cross examination. Now, you also have a right to waive or give up, which means to give up your right to have witnesses. What that means is that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in their case. Now, you also have what is called a Fifth Amendment right against self-incrimination. What that means is you have a right to remain silent. The state, the government, the DA's office cannot force you to testify against yourself. If you decide you don't want to say nothing, they can't call you to the witness stand to testify in your case. They have the burden of proof. They have to prove you guilty. You don't have to prove yourself guilty. Okay? And so, however, you can waive or give up your right against self-incrimination. All right? If you waive or give up the right against self-incrimination, that means you're saying that you will take the witness stand. But you do not have to if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, the Fifth Amendment is the Fifth Amendment of the United States Constitution. Okay, when I use that term Fifth Amendment, I'm talking about the United States Constitution that gives all of us the right to remain silent. All right, now, you also have a right to have what is called discovery. You want to go to trial? And what discovery is, you have the right to see or have access to the state's file, to see what evidence they have against you. All right, we call that discovery. All right, now, as I mentioned to you earlier, you have a right to have access to witness statements, your statements, police reports, lab reports, photos, video recordings. You have a right to have access to audio recordings, instruments, documents, or whatever they have. You have a right to have access to it. That's called discovery. Now, you also have a right to waive or give up your right to have discovery. If you say, I don't want to see that, then you have a right to do that as well. All right. Now, everyone that's here today, one, you've been charged with an offense, you've been arrested, you was placed in jail, you're out of jail on bond, you're out of jail on a cash bond, which means you pay the full amount of bond to get out of jail. You're out of a surety bond, which means you pay the bond for a percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you do not have to pay any money to get out of jail. You was just released under your own personal recognizance. Now, the reason why I mention that is because every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you talk to the prosecutor or the attorney talk to the prosecutor, and they're trying to work out a plea bargain, they offer you to serve 5 days in jail. That means you won't have to serve no more time in jail because you'll be given credit for the time that you have already served. Now, if they offer 7 days in jail, you serve 5, that means you would have to serve 2, because we'll subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You receive $100 credit for every day that you spent in jail. Now, the operative word that I use is day. And the reason why I use that is because let's say you went in jail, you was booked into jail at 11:59 p.m. on last night. And then you bonded out of jail at 12:01 a.m. this morning, 2 minutes later. That's 2 different days. So you get credit for 2 days, not 2 minutes, you get credit for 2 days. It's not based on 24 hours, it's based on different days. All right, so if you, and the other thing is that you get credit, as I mentioned to you, $100 per day. So if you spend 5 days in jail, that's $500. If the state is offering you fine and court costs of $500, that means you won't have to pay anything. Why? Because the time you spent in jail has already paid it all. Therefore, you'll be the fine and court costs will be taxed at the time. Now, if they are offering finding court costs of $700, then you would only have to pay $200 because you already have $700, you already have $500 that we're gonna subtract from the $700, that leaves $200. You'll be required to pay the $200 on the day that your case is disposed of. Now, if you cannot pay it on the day that your case is disposed of, no problem. Because we could put you on what is called payment plan, where you can pay off the fine and court costs in small monthly installments until it's paid off. Now, even if you do not have the ability to pay off the fine and court costs, even if we put you on a payment plan, no problem, we can convert the fine and court costs to community service. And so every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited toward your fine and court costs. So what that basically means, you work 8 hours, community service one day, that's $100. That will go toward your fine and court costs. So in our scenario, you work 2 8-hour days, that's $200. And you've already paid up your fine, your balance on your fine and court costs, okay? Now, everybody that's here, you should be aware that the state has a program that is called pretrial diversion. And what that means is if you've never been in trouble before, the first time getting in trouble, the state, when I say the state, I'm talking about the district attorney, they have a program where they would dismiss your case. And you could get it wiped off your record. We call it expunged. The way it works is it has to be your first time getting in trouble. You have to have a lawyer to help you with the application process. And it cannot be an offense for unlawful carry a weapon or resist arrest. Now, if you qualify, you get into a program, they dismiss the case, you complete the program, you can get it expunged, which means deleted, wiped off, or erased from your criminal record. All right. Now, if now the district attorney has another program that is called Veterans. Yes. You can do that with a site. Yeah, with code point art. Yeah. So the district attorney's office has another program that is called Veterans Court. With Veterans Court, it means that if you are a veteran of any one of the branches of the United States military, anyone, they have a program where they will dismiss your case. And once you get into the program and complete the program, they will dismiss your case, and you can get a non-disclosure where your record is sealed to the general public. Okay? But you have to be a veteran of any one of the branches of the United States military. All right. Now, this court has a program that is called pretrial diversion. That's a program that God led me to start within the first 100 days of taking office, which was in March of 2017, was when the program got started. Now, the program is designed to address the issue of what we call recidivism. Recidivism means when people commit crime over and over. Okay? We started the program to address the issue of recidivism. And with the program basically entails we have partnerships with local agencies in our community. One of the agencies that we have a partnership with is our Spindletop Center, which is a local mental health center in our Southeast Texas region. And we have some representatives from Spindletop. They're going to come to you in a few minutes and tell you a little bit more about the program that Spindletop has to offer. Now, basically, what Spindletop will do, they can do a private interview, either in our jury room, at their facilities, by telephone, whichever is convenient for you. They have the ability to also do an assessment to determine what a mental health issue may be, and they can develop a treatment plan for either outpatient, inpatient treatment. Now, you do not have to be incompetent or insane to participate in the program. You can just merely suffer from anxiety or depression or any other host of mental illness. And they have the expertise to address your mental health needs. Now, Spindletop has another program that is called ATAR. And What that is, it's a drug and alcohol recovery program. You have issues with drugs and alcohol. Phenotype has a program that is called ATAR, and we also have a partnership with our local drug and alcohol counselor. That is a program that is called OZAR. Now, ATAR is an acronym, ATAR, that stands for addiction, treatment, and recovery. Okay? It's an alcohol treatment and recovery program. And OZAR is an outreach, which is OSAR, outreach screening, assessment, and referral. Both of those programs are drug and alcohol recovery program. And what they would do a private screening, assessment, and they could develop a treatment plan for either outpatient or inpatient treatment. Now, if you are unemployed, if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, then they will assist you in getting a job in the area that you're trained in. Now, if you have not graduated from high school, or if you do not have a GED, then we have, they also have a GED program where you can receive your graduate equivalent diploma. Now, all of these programs that I just mentioned will not cost you anything, they're free, will not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we can direct you to the people that you need to talk to. We can give you the brochures, the phone numbers, so that you can get into any one of these programs. And as I mentioned to you earlier, we also have, folks from Spindletop. They're going to come to you and give you a little bit more information. And then after that, we have time with the Violence Intervention Program, which is also part of the pretrial diversion program. And we have Deputy Barry and Caitlin. They're from Spindletop. They're going to tell you a little bit more about the program that Spindletop has started.
Thank you, General. Good morning, ladies and gentlemen.
Good morning.
As we said, my name is Patricia Berry. I am a deputy with the Jefferson County Sheriff's Office. And my partner Caitlin here is a qualified mental health professional with Spindletop Services. So today we're here in this courtroom because, as you've seen, the judge cares about each and every person that enters this courtroom. And we find that statistics have shown oftentimes people who enter the criminal justice system oftentimes have mental health needs that are not being met, or substance use issues, or just simply a lack of resources. That's what we're here to offer you today, is just the opportunity and the availability of those resources. Now, on that clipboard that you sat next to whenever you walked in, if you notice on the top, there's a small piece of paper. So that small piece of paper is one that we handed out initially, and that is a voluntary piece of paper. It's not mandated by the court. You're not required to fill it out. This is a way for us to contact you if you do need those resources. My partner Caitlin is going to explain to you briefly on how to fill that out and how she can contact you better.
At the top of that paper is basic information. It's your name, phone number, birthday, email. We need those things to put you in our system and to be able to contact you. Underneath that is how would you like to be contacted, and the options are call, text, and email. Whatever you check is how I will contact you. I will not contact you unless you check that box. Underneath that is resources that you would like assistance with. And most of them is I send you a form that you have to fill out, or I send you a link to a website that you have to go on and you have to do those things yourself. If you were to check mental health, which could be PTSD, depression, or anxiety, or substance use, which could be any type of drug or alcohol, then you can work with Spindletop and we can get you the services, the resources, and the support that you need to handle those things. Everything else is pretty much self-explanatory. If you'd like to talk to me in person and get into services, when the judge calls you up and he's done with you, I will come get you. I'll pull you to a back room and then we can talk privately. If you'd rather I call you today, then you can write, please call me today on your paper. But if it doesn't matter, when I get to you this week, you can just check the call box.
In a few minutes, we're gonna come around and we're gonna hand out, business card here, this is just a business card. It has a telephone number on the back that is a 1-800 number, and this is a crisis hotline number. It's available 24 hours a day, 7 days a week. You can contact us, you can give this to a friend, you can give it to a family member, whoever it is that you need to talk to. If you want to talk to us whenever we come by, feel free to talk to us. That's what we're here for. And we just want to let you know, we do. We hear the need that comes back from the community, the need for these resources. Oftentimes you just don't know where to look. That's what we're here for. So feel free to talk to us whenever we come by, and thank you very much for your time.
Okay, thank you, Deputy Gary Caitlin.
Yes, sir.
Johnny?
Thank you, Judge. Good morning.
Good morning.
I'm Johnny Stewart. I'm with the Family Services of Southeast Texas. Many of y'all may probably already know about the Women's and Children's Shelter, but we also provide services concerning counseling and education. This program, one of the pretrial diversion programs, is if you have been arrested for domestic violence or family violence, we have a program which is called Batteries Intervention and Prevention Program. It's an 18-week program, 2 hours per group session. And once it gives you tools and information how to be nonviolent in your relationships. Also, it's going to help not only you, but it's going to help your family members also and the children. So this is one of the programs that we've been offering for over 50 years at Family Services. So take advantage of that if you have been involved in a domestic violence, or they call it family violence today. Hey, take care of look into this program. This is going to be something that's going to not only help you, but help your family members and help others. And help you, if you're not currently in a relationship, help you in the future relationship. So there's the brochure is going to be at the end of the, I'll leave a few. That's something that you think that might work for you. Hey, we'll be happy to have you in the program. So thank you very much. Okay.
Thank you, Judge. Okay, thank you, Johnny. Okay, now, ladies and gentlemen, the paperwork that you have in your clipboards, we're gonna pick that up. If you need any help filling out the clipboard, we have our core personnel, including myself. We'll be happy to help you to finish filling out the paperwork. Now, we're gonna call you up before the bench, one at a time. Once we get the paperwork, we're gonna put you into 1 of 3 categories. 1, if you'd like to hire your attorney. 2, if you'd like to apply for court-appointed attorney. And 3, if you'd like to represent yourself. Okay? Now, it's gonna take us a little time to make sure that all the paperwork is filled out properly. And if you need to use the restroom, there are 2 restrooms right out in the hall. There's a main restroom in front of County Court number 3. And on the opposite side of the hall, in front of 172nd District Court, there's a female restroom. Now, you're allowed to use the restroom. Now, please do not leave the courthouse. If you leave the courthouse, your name is called, you're not here, your bond will be forfeited. And if your bond is forfeited, that simply means that a warrant will be issued for your arrest. At some point, you'll be arrested, placed back in the Jefferson County Jail, and guess what? We have to go through all of this all over again. Okay. So, it's gonna take us a few minutes. The other thing is, be mindful that we're still in court. So you need to conduct yourself accordingly. As I mentioned here, it's gonna take us a couple of minutes to make sure we get all the paperwork. And if you need some help, just raise your hand. And if somebody will come out to help you, or I'll ask you to come up to where I am, and then I'll be able to help, okay? But this time, the court will be in recess. Okay, ladies and gentlemen, we're getting ready to get started again on the arraignment. When I call your name, please come forward before the bench. Charles Jason Kramer. Okay, Mr. Kramer, your full name is Charles Jason Kramer.
Yes, sir.
Would you please raise your right hand? Mr. Kramer, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Kramer, you may put your hand down. Mr. Kramer, first of all, how are you doing, Mr. Kramer?
Good, how are you?
I'm doing fine, thanks for asking. Mr. Kramer, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Sir.
And are these your initials on the line that state you'd like to apply, that you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Kramer, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Kramer. Your case is going to be reset to give you an opportunity to hire an attorney. Please have a seat in that first chair on the wall. Wait for your name to go. Jermaine Beverly. Mr. Beverly, your full name is Jermaine Paul Beverly Jr.
Yes, sir.
Mr. Beverly, would you please raise your right hand? Mr. Beverly, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Beverly, you may put your hand down. How are you doing, Mr. Beverly? I'm doing fine, thanks for asking. Mr. Beverly, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that states you'd like to apply for court-appointed attorney? I also have another document that is titled Governor County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature? Okay, Mr. Beverly, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Beverly, I read your answers. Your answers to meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you. You will also be given information to contact him. Court coordinator will give you that information. Once she gives you that information, you'll be free to go. But before she gives you that information, the bailiff is going to have you some bond conditions. I'm going to go over these bond conditions with you. That document is titled Standard Bond Conditions in County Court at Law Number 2. You can see that document. And it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
Condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition? And condition number 4 doesn't apply. Condition number 5 does apply. Condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a subdivision, of a political subdivision or state agency. Do you understand that condition? Now, if you violate any one of these conditions, your bond can be revoked and if your bond is revoked, a warrant will be issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Please, have a seat in that first chair and wait for your name to be called. Tyler Callahan. And you have a blessed day. All right. Mr. Callahan, your full name is Tyler E. Callahan?
Yes, sir.
Mr. Callahan, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How you doing, Mr. Callahan?
Good.
I'm doing fine, thanks for asking. Mr. Callahan, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? Mr. Callahan, before you signed and initialed these documents, did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? And Mr. Callahan, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court appointed attorney. The attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will give information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair. Damon Collins. Mr. Collins, your full name is Damon Collins Jr. Would you please raise your right hand? Mr. Collins, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Collins, you may put your hand down. How are you doing, Mr. Collins? That's good. Now, Mr. Collins, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Collins, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Collins, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court appointed attorney. And so at this point, you have two options. Since you do not qualify, you can ask that your case be reset to give you an opportunity to hire your own attorney, or you can waive your right to an attorney and represent yourself. Okay. He had a raise one earlier. Where is it? Okay. Just give him a waiver and he can have a seat at in that chair at the table. Right there. She's gonna give you a pen too. We'll call you back up in a little bit. Michael Diaz. Mr. Diaz, your full name is Michael Diaz. Mr. Diaz, would you please raise your right hand? Mr. Diaz, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Diaz, you may put your hand down. How are you doing, Mr. Diaz? That's good. Now, Mr. Diaz, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to apply for court appointed attorney? I also have another document that is titled Judge's Explanation, that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Diaz, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Diaz, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court appointed attorney, and the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. But before she gives you the information, the bailiff is gonna hand you a document that is titled Standard Bond Conditions in County Court Order Number 2. I'm gonna go over this document with you. And Mr. Diaz, this document states following return of approved information in County Court Order Number 2. All bail bonds executed for release of any defendant named here in or subject to the additional condition. Number one, the defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol in the test in the case of presence of drugs and alcohol in the defendant's body. You understand that condition? And condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? And condition number four doesn't apply on the next page. Condition number five does apply. Says that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Diaz, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You understand? Okay. Yeah, please have a seat in that chair and wait for your name to be called. Yeah, bless that. Chastity Eves. Miss Eves, your full name is Chastity Faith Eves? Miss Eves, would you please raise your right hand? Your other hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Miss Eves?
Great.
That's good. Miss Eves, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. She didn't put her initials down here.
Oh, I know. I know.
We're being here for this showing. You've been here for the other one, which occurred on the same day.
Justice in charge now.
That's what you were here for. You've never been here for the assault.
I was in the court with students.
That's a felony thing. What has nothing to do with that?
No, this is the same.
This is a misdemeanor charge. It's not a felony.
I've already spoken with the prosecutor there, as well as Cheryl and Cindy now. They're the ones that have the assault charge, correct?
I don't. Is that the check?
Okay, now, Miss Eves, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Do you recognize this document? Is this your signature? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Correct.
I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Now, Ms. Eves, before you signed and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Eves, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney that's appointed to represent you as attorney John Macy. Attorney Macy will be given information to contact you. You will also be given information to contact him.
Okay.
Our court coordinator will give you that information. But before she gives you that information, the bailiff is going to hand you a document that's titled Standard Bond Conditions. I'm going to go over these bond conditions with you. And it states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
So what is the bond thing for getting a lawyer?
No. You are out on bond and these are your conditions of your release.
I was released not on bond, sir. I wasn't released on bond.
You wasn't released on bond. They just let you out the jail.
Yes, sir.
Just said go.
They left me to my mom.
Okay, but when you get out of jail, you're either out of jail on a cash bond, a surety bond, or a PR
There
bond.
was a surety bond from the previous one.
Well, you have a bond then.
No, it's been paid for, my $50,000 bond. Sorry, it's been paid for, it's over. Are you spoken about bail bondsman? For American bail bondsman? I talked to them yesterday.
Okay, hold on, I'm gonna pull up your file.
Okay, there's a $50,000 bond. That's been paid for,
So if the bond is paid for, you out on bond.
but this is the second time I've been to court with y'all for this allegations of assault. And I do have the correct paperwork outside, sir. If you please allow me the blessing to just.
This
go down.
bond is $2,500.
That is a $50,000 bond,
Well, that's in another case.
another case.
It has to be because it's not in this case. This case has a $2,500 bond that was posted on March 24th of 2025.
Really? I have no knowledge of this at all.
Well, that's why I'm telling you.
Okay, I think I want to go ahead and try to hire a lawyer.
Okay, that's fine.
'Cause this is.
But,
different
hold on,
because
okay, that's
it's
fine, but-
confusing,
Okay,
'cause-
but let me tell you this here. I'm getting ready to go over these bond conditions with you, so you just need to listen.
Okay.
Because if you violate any one of these bond conditions,
Yes, sir.
your bond can be revoked, you'll be arrested and placed in the Jefferson County Jail.
Yes, sir.
Okay. So condition number one, the defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition? Condition number two, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir. And could you tell me the defendant, sir? I mean,
Well, let me go over these bond conditions.
Yeah, I'm sorry. I'm so sorry, sir. My apologies.
Okay, do you understand that condition?
Yes, sir.
Condition number three, defendant shall not communicate either directly or indirectly with the alleged victim of pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Hold on a minute. And the alleged victim in this case is Cheryl Ann Noel.
I've only gone to court twice now for this, sir.
Well,
This is
Th-
for the
this-
record, yes, sir, it is.
okay, well, you can take that up with your attorney as, this case was just filed
I've been
in
my
March
own lawyer.
25th, 2024.
I've been my own lawyer throughout this whole thing, sir.
Okay,
Pretty
okay,
much,
well,
because
if that's true, then it'll be resolved. But until that happens,
yes, sir.
this case is still pending.
Okay, that's fine.
Okay. Now, do you understand that condition?
Yes, sir.
All right. Now,
And you said-
condition number 4 does not apply. Condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code Act if engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir, and I would love to be a part of the state agency.
Okay. Now, Ms. Eves, if you violate any one of these conditions,
Yes, sir.
your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You will be arrested and placed in the Jefferson County Jail. Do you
Yes, sir.
understand? Okay. Now, Ms. Eves, have a seat in that first chair. Wait for your name to be called. No, you said that she wanted to change her, she wanted to hire a lawyer, right? Okay, so we gotta remove what we had.
So you don't want the toilet.
Here you go.
Yes.
Okay,
Want to make sure.
she wanna change. We gotta take,
Sign out.
right. Okay. The case is gonna be reset to give you an opportunity to hire your attorney.
And can I get
Please have a
records-
seat in the. Can you do what?
Can I get records of the first bond that was issued, the 25?
Yeah,
I don't have that on my file.
yeah, you have to go to the county clerk's office, which is located
Thank you so
on the
much.
first floor. Okay.
Just haven't seen that card yet.
Oh, this goes with that. Donnie Elmore, the third. Mr. Elmore. Your full name is Donnie Earl Elmore, Donnie Elmore? The third? Okay. Mr. Elmore, would you please raise your right hand? Do you swear affirm to tell the truth or whole truth and nothing but the truth, so help you God? Mr. Elmore, you may put your hand down. How are you doing, Mr. Elmore? I'm doing fine, thanks for asking. Mr. Elmore, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that is states you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? Okay, now, Mr. Elmore, before you signed and initialed these documents, did you read the documents? Do you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Elmore, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Attorney that's appointed to represent you is Attorney Christy Carlton. Attorney Christy Carlton will be given permission to contact you, and you will be given permission to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. But before she gives you that information, I need to give you some bond conditions. Would you please step over here, please? And then you can step back. Okay. Now, Mr. Elmore, the document that you just received is titled Standard Bond Conditions in County Court at Law Number 2. And it states following a return of permanent information in County Court at Law Number 2 of Jefferson County, Texas. All bill bonds executed for release of any defendant name you herein or orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest if any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition? Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. Condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, this says unless defendant is a peace officer. Well, it says you'd have as defined by section 1.07 of the penal code. And so you'd have to go to the Texas Penal Code, look at section 107 and see if you fall within the meaning of a peace officer. Okay? All right. Now, do you understand these bond conditions? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant of issue for your arrest, you'll be arrested, placed in the Jefferson County Jail. Now, you're gonna have a seat in that first chair. Wait for your name to be called. Once your name is called, oh, I already told you who his lawyer was, right?
Yes.
Okay, yeah. Once your name is called, you go to the window, and once you finish, you're free to go, and you have a blessed day. All right. Mallory McBee. Okay, Miss McBee, your full name is Mallory Anna McBee?
Sorry, Ann.
Oh, damn. Okay, that's Anna. Now, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How you doing, Miss McBee?
I'm good. How are you doing?
I'm doing fine, thanks for asking, Miss McBee. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for the appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Independence. Do you recognize this document?
I do.
And on page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes,
Ms. McBee, before you sign and initial these documents, did you read the documents?
I do.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. McBee, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information once she gives you that information. You'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall. All right, you're welcome. Stephanie Hamill. Ms. Hamill, your full name is Stephanie Michelle Hamill.
Yes, sir.
Ms. Hamill, would you please raise your right hand? Ms. Hamill, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Hamill, you may put your hand down. How are you doing, Ms. Hamill?
Okay.
I'm doing fine, thanks for asking. Ms. Hamill, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled
Yes.
Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. This is your signature.
Yes, sir.
Now, Ms. Hamill, before you sign and initial these documents, did you read the documents?
Yes,
Did you understand what you read?
yes,
And is everything in these documents true and correct
yes.
to the best of your knowledge? Ms. Hamill, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. Before she gives you that information, the bailiff is going to give you some bond conditions that I need to go over with you. And the document is titled Standard Bond Conditions in County Court at Law Number 2, and it reads as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. You understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not apply. However, condition number 4 does apply because you have a DWI second which is listed as a subsequent offense under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
I already have it in my car.
Okay, so if you already have it, we need to give us a copy of the contract
Okay.
showing that you have that document.
Yes.
I mean, that instrument. Now, do you understand that condition?
Yes.
Now, defendants, and you'll have 3 days to get that to us. They can give you the email address or the fax number, so it can be faxed. Number 5, defendant shall obtain, maintain, and pay for, and have no violations within interlock ignition device, mobile device. Any violations will be grounds for revocation. Do you understand that condition?
Yes.
And condition number 6, defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that?
Yes.
Now, I have verification forms that I can give to you. And locations of AANA meetings. Now, every time that you come back in the court, you need to bring that verification form with you so that we can verify that you have been attending AANA meetings. Okay? Now, Ms. Hamel, just have a seat in that first chair, wait for your name to be called. Once your name is called and you finish at the window, you'll be free to go, and you have a blessed day. Thank you. You can get. Give her that email or that fax where she can send that information. Who we have? That is the lady that's on Zoom. What's her name?
Next Tuesday.
Okay, Miss Williams, that's on Zoom. You,
I'm Miss Washington.
oh, let's see, okay. Kelly Washington,
Yes, sir.
how are you doing?
I'm okay. How you doing?
Okay, I'm doing fine. Now, your case is being reset to when?
The 13th, May 13th.
Okay, your case is reset to May 13 at 9 AM.
Okay.
Your bondsman will be given notice of that. Oh, she on personal bond, so. Do you need to be in court in person on the 13th of May 2025, which is next week, is that correct? All right,
Tuesday.
so it's
Okay.
next Tuesday. All right, you're free to go and you have a blessed day.
Okay. Thank you so much.
Okay, you're welcome. William Waller. Mr. Waller, your full name is William Merrick Waller.
Yes, sir.
Okay, Mr. Waller, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Waller, you may put your hand down. How are you doing, Mr. Waller?
Okay, how you doing?
I'm doing fine. Thanks for asking. Mr. Waller, the state is represented in this case by attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's great. Now, Mr. Waller, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay, Mr. Waller, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, it is.
And are these your initials on the line that state you would like to waive your right to attorney and represent yourself?
Yes.
I also have another document that's titled Waiver of Counsel for Purposes of Entering Guilty Plea Proceedings Trial. Do you recognize this document?
Yes, it is.
And is this your signature on the line that's titled Defendant?
Yes.
Okay, now, Mr. Waller, before you signed and initialed these documents, did you read the documents?
Yes, I did.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Waller, I also have before me a document that is titled Information on my computer. This document was filed by the District Attorney's Office. In this document, it alleges that you, William Merrick Waller, on or about December 28th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana. Do you understand what you've been charged with?
Yes.
And to this charge, how do you plead? Guilty, not guilty, no contest.
No contest.
Now, you're pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Now, Mr. Waller, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, I do.
On page 2 of this same document, there are a set of initials, two sets of initials. First set of initials is the lower paragraph that is titled Waiver and is on a line next to boxes check nolo contendere, which means no contest. Did you place your initials in this location?
Yes, I did.
Also, the second set of initials is below a paragraph that is titled Discovery Admonishment, and the initials are on a line next to a statement that reads, I do not request discovery. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. And did you place your initials on this document?
Yes, I did.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And the next document is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, I did.
Now, Mr. Waller, before you sign and initial all of these documents that I just showed you, did you read the document?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Waller, are you a citizen of the United States?
Yes.
State offers State's Exhibit 1, Your Honor.
Mr. Waller, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's exhibit number 1 is the first document that I showed you. This is the same document. This is the same document that have your initials in these 2 locations on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay. Okay. State's exhibit number 1 will be admitted. Mr. Waller, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Okay. Mr. Waller, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 2 days county jail with credit for time served of 2 days. And we'd ask that Mr. Waller be given credit for the 2 days to go towards his court costs in this matter.
Okay. Mr. Waller, the state is offering that you serve 2 days in the Jefferson County Jail. You'll be given credit for the 2 days that you've already served. And what's the court cost? The court cost in this case is $277. With the 2 days credit, that means you will only have to pay $77 because you have $200 that's given that is credited toward the $277.
Yes.
Now, will you be able to pay the $77 today?
Yes. Can I put it on a credit card?
They take credit cards downstairs. Okay, now, Mr. Waller, do you understand the state's offer?
Yes, I do.
And do you think that the state's offer in your case is fair and just?
Yes, I do.
And do you accept the state's offer?
Yes.
Okay, Mr. Waller, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Waller, you understand next to the bailiff, follow her directions and she can give you directions to the county clerk's office, which is downstairs. And once you go downstairs, they're gonna give and pay it. They will give you a receipt. You need to bring that receipt back into the court and give it to the coordinator.
Okay.
All right, just stand next to the bailiff. Stacey Adams.
This week, there's one thing that we need to add to the paperwork. I did not put the no contact. Thank you, Judge.
Okay. Mr. Adams, your full name is Stacey Adams?
That's right.
Mr. Adams, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Adams, you may put your hand down. How are you doing, Mr. Adams?
Fine, how are you?
I'm doing good. Thanks for asking. And Mr. Adams, state is represented in this case by attorney Andrew Hubel. And Mr. Hubel, how are you doing?
Doing well, Judge. Thank you.
Now, Mr. Adams, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Put it right there. Do you recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Inter Guilty Plea Proceeding this trial. You recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant? Now, Mr. Adams, before you sign and initial these documents, Did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Now, Mr. Adams, before we go any further, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay. Now, Mr. Adams, also, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Adams, it alleges that you, Stacy Adams, on or about January 6th of 2025, while you were in Jefferson County, Texas, that you committed the class A misdemeanor offense of assault, family violence. Do you understand what you've been charged with?
Yes, sir.
And to this charge, how did you plead guilty, not guilty, no contest?
Thank you.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Sir.
You're pleading no contest because you do not wish to fight or contest the charges. That's what no contest means.
Yes.
Now, Mr. Adams, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of initials. One set of initials is on a line next to a box that's checked no contendere, which means no contest, and it's below a paragraph that is titled waiver. You place your initials in this on this document.
Yes, sir.
The second set of initials is below a paragraph that is titled discovery admonition or admonishment. And it's next to a statement that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, there's a, do you recognize this document? This document is titled Trials Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir. It is.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand this statement?
Yes, sir.
Second box is checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
Okay. Now, Mr. Adams, before you signed and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Adams, are you a citizen of the United States?
Yes, sir.
Separate states one.
Mr. Adams, the state is offering state's exhibit number 1 to be used as evidence in your case. State's exhibit number 1 is the first document that I showed you on this tablet. This is the same document that have your initials in the 2 locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objections. State's exhibit number 1 is admitted. When you locked out, could you, on Adams, you could unlock it. And Mr. Adams, is there any evidence that you're currently mentally incompetent to stand trial? Okay. Okay, Mr. Adams, I will accept your plea no contest. I will find that you're mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 180 days probate over 1 year with a $500 fine, 30 hours community service, and defendant instead no contact with the complaining witness, Tanya Tucci in this case.
Okay.
And forgot to mention, defendant has 1 day jail credit, which is to be credited towards final court costs.
Okay.
Okay, what is this, courthouse? Did they have on there? Talk to him first, see what they did. Okay, Mr. Adams, the state is offering that you serve 180 days in Jefferson County Jail. You will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, reimbursement fee of $15 a month, and you'll be required to pay $100 to a family violence center in our community. Your total monthly installments, that is the total amount that you will be required to pay each month, is $163 a month. Will you be able to pay the $163 each month?
It's okay to answer honestly.
Yeah, it's not gonna change the offer, is it,
Just answer honestly.
Right now, so.
okay, we need to get an F, hold on, let's see if they have one in here. Hold on a minute.
I'm trying my best.
No, just hold on a minute.
What's gonna happen, what he's going to do is he's gonna look at your updated other agenda, make sure that's still correct, like your income and all that information. And then if the court finds you indigent, what will happen is the time.
Oh, he doesn't have one in
Emergency service, so.
I don't see it in, we're gonna have to give him, Ms. Mosby, we're gonna have to give him an affidavit to fill out. You're gonna have a seat at that table. And she's gonna give you just the affidavit to fill out so we can get your financial information. Okay, we'll call you back up.
What was his name?
Stacy Adams. You're gonna have to send this back to me. Yeah. Who's that? Brenna Boudreaux?
I'm sorry, but we're burning our way.
Ms. Boudreaux, your full name is Bernaya Boudreaux.
Yes, sir.
Ms. Boudreaux, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Boudreaux, you may put your hand down. How are you doing, Ms. Boudreaux? I'm doing fine, thanks for asking. Ms. Boudreaux, I have before me on paper, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? Or these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Ms. Boudreaux, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Boudreaux, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Bernaya Boudreaux, on or about November 13th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Ms. Boudreaux, do you understand what you've been charged with? And to this charge, Ms. Boudreaux, how do you plead? Guilty, not guilty, no contest?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes.
Ms. Boudreaux, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, BB, on the line next to a box that says check guilty. Did you place your initials in this document? Second set of initials is below a paragraph that is titled Discovery Admonishment, and is next to a statement that reads, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials in this location as well? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document, there's titled Trial Court Certification of the Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Boudreaux, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge? Ms. Boudreaux, are you a citizen of the United States?
Yes, sir.
Chapter
State,
6-1.
Ms. Boudreaux, state is offering State's Exhibit Number 1 to be used as evidence against you in your case. State's Exhibit Number 1 is the first document that I showed you on this tablet. It is the same document that have your initials in these two locations, and it has a it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's Exhibit Number 1 will be admitted. Now, Mr. Boudreaux, is there any evidence that you are currently mentally incompetent to stand trial? That means, is there any evidence that you have a mental illness where you don't understand what's going on? Okay. Ms. Boudreaux, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now, just as a abundance of caution, the second document, Trial Court Certification, the Defendant's Right of Appeal, do you recognize this document? And at the top of this document, there are two boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
And the second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to appeal. You understand the statement?
Yes, sir.
Okay. Now, Ms. Boudreaux, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Could you send her case back to me? State. Do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
The agreement in this case is to 1 year deferred probation with a $300 fine and 40 hours community service. This defendant has 6 days jail credit, which will be credited to his fine and court costs.
What is her court cost? 277? Wow. Okay, now, Miss Boudreaux, state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300. Plus, you'll be required to pay a court cost of $277. You'll be required to pay a probation fee, $6 a month, your analysis fee, a $15 a month reimbursement fee of $15. Now, you will receive 6 days credit that will go toward your fine and court costs, which means you will not have to pay the fine and court costs because it's already been paid by the 6 days that you've already served in jail. Okay? So, hold on a minute. So instead of paying $136 a month, you'll be required to pay $83 a month. Will you be able to pay the $83 each month?
Yeah.
I just need to know. Would you be able to pay the $83 a month? Okay. Now, you will also be required to perform 40 hours of community service. Let's see. And you'll be required to adhere to the other standard terms and conditions of this probation. Do you understand?
Yes, sir.
All right. Now, Ms. Boudreaux, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
Yes.
Do you accept the state's offer?
Yes.
Ms. Boudreaux, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Boudreaux, if you successfully complete this probationary period, this case will not result in a conviction on your record. And you may qualify for non-disclosure when you're ready to seal to the general public. And you can talk to an attorney about that.
Yes, sir.
All right. Please stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. And you have a blessed day.
Paperwork. We, only in 277, it came out to 337. Because they have, these officers be in the bond, that's just like,
Well, we have to call it back up, so.
okay.
Did they already? Okay, we should have told them that before we went down, yeah. Whose case was that? Mr. Waller, would you please come back up? Okay, Mr. Waller, you previously entered a plea of, no contest. The state, offered that you serve 2 days in jail, but, you've already served 2 days in jail, so you was given credit for the times that you had already served.
Yes.
And the court cost, in this case, we told you it was $277, right? But it was actually what?
337.
Actually, $337. And you had 2 days credit. So that would have been five. Wait a minute. 2 days credit toward that, so it would, so instead of paying 337, it would be 137.
Yeah, okay.
Okay,
Yeah,
will you be able to pay the 137?
yes.
Okay. Okay. She'll just stand
There it is.
before the, she can give you judgment, okay?
All right.
It's judgment of state.
Right back.
All right,
Thank you.
okay. Mr. Stacy Adams?
That was last time.
Now, Mr. Adams, you previously entered a plea of no contest, is that correct? And the state had offered that you serve 180 days in jail, probated for 1 year, $500 fine. Those court costs are $277. You was required to pay a probation fee of $6 a month, you'd have to pay $15 a month, reimbursement fee of $15. And you know what? This should be a little less. Let me do this here, that'll be 1692, not 17. Hold on, it should come out a little less. You'll also be required to pay a probation fee, $6 a month, you're now to pay $15 a month, reimbursement fee of $15, and you're required to pay $100 to a family violence center in our community. Now, let's see, you got 1 day's credit that will go toward your fine and court costs. So it should be 630. And so your total monthly installments will be $153 a month. Will you be able to pay that $153 each month? Now, do you understand the state's offer?
Yes, sir.
And do you think the state's offer in your case is fair and just?
Sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Adams, I'll follow. People are in agreement that you have entered into with the state. Mr. Adams,
Have a seat.
just have a seat and wait for your paperwork.
Thank you.
That'll be quick, Very good, man. No,
Okay, next. We have Damon Collins. Okay, Mr. Collins, your full name is Damon Collins Jr. Please raise your right hand. Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Collins, you may put your hand down. How you doing, Mr. Collins? I'm doing fine, thanks for asking. Mr. Collins, you have a right to have the record of this proceeding. You also have a right to waive your right to have a record. Do you waive your right to have a court reporter to type down everything that's being said?
No.
You okay? Have a seat. We got to get us a court report.
no, yes.
Okay, now, Mr. Collins, I also have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this document, it alleges that you, Damon Collins Jr., on or about December 21st of 2024, while you were in Jefferson County, Texas, that you committed the class A misdemeanor offense of resisting arrest, search, transportation. You understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest?
Okay.
Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Okay, Mr. Collins, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document? This document is also labeled as State's Exhibit number 1 on page 2 of this document. There are 2 sets of initials. First set of initials, the lower paragraph that's titled waiver, and it's on a line next to a box that's checked Nola Contendra. Did you place your initials in this location?
Yes,
Second set of initials is below a paragraph that is titled discovery admonishment, and these initials are on a line next to a statement that reads, I do not request discovery. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in this location as well? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification, the defendant's right of appeal, you recognize this document. And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have the right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
sir.
And is this your signature online and titled defendant? And are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
Sir.
I also have, let me do this here. Also, they had it in 2 locations, so I took out the one that didn't apply.
No problem.
Also, I have another document that's titled waiver of counsels for purposes of entering guilty plea proceeding and trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, Mr. Collins, before you signed and initialed all these documents, did you read the documents? And did you understand everything that you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Collins, are you a citizen of the United States? Mr. Collins, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that you acknowledged on this tablet. This is the same document that have your initials in these 2 locations. And on page 3, it has your signature. Is it all right for the state to use this document as evidence in your case? Okay, Mr. Collins?
No.
Is there any evidence? Well, State's Exhibit number 1 will be admitted now, Mr. Collins. Is there any evidence that you are currently mentally incompetent to stand trial? Mr. Collins, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state offering 1 year deferred probation, $200 fine with 1 day jail credit to be accredited towards fine and court cost, 24 hours community service and court cost as well. Did you need a copy of what you want? Well, you can, do you need a copy of your receipt?
Could you send Collins' case back to me? A representative. Well, we can't accept any communication there's something that's called ex parte communication. And we have to we have what is called a code of judicial conduct that prevents us from communicating with someone or any form of communications outside of the court without the presence of all parties involved. Yeah, but I mean, I can't, unless you wanted to provide it to them, but I can't. That's called ex parte communication, whether it's verbal, written, text, or any form of communication. Okay. Okay, now let's see, where were we? This is what's this court cost?
277.
277. Okay, Mr. Collins, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $200 plus court costs of $277. You'll be required to pay probation with $6 a month. You're now to pay $15 a month reimbursement to the $15, and and this will be a total each month of monthly installments of $127 a month. Will you be able to pay the $127 each month? You will also be required to perform 24 hours of community service and adhere to the other standard terms and conditions of your probation. Now, Mr. Collins, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Collins, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Collins, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction in your record and may qualify for a non-disclosure. You can talk to an attorney about your non-disclosure. All right? Yeah.
Okay.
Yes.
Thank you, Jeff.
Okay, Have a seat and wait for your name to be called and follow the directions of the fairly. Mr. Horace Jones. I have this here.
You wanna send this to me?
Did anybody talk to him? Oh. Okay. Okay, now, Mr. Jones, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down, Mr. Jones. Your full name is Horace Jones Senior. Is that correct? Okay. How are you doing, Mr. Jones?
Yeah, sure.
Well, I'm doing fine, and thanks for asking. Let's see. Hold on, let me see. Now, Mr. Jones, initially, I have, you first fill out a document stating that the document is titled Judge's Explanation of Rights to Defendants Without Attorney. And you stated that you wanted to waive your right to attorney to represent yourself, and you talked to the prosecutor, is that correct?
That's right.
Now, after talking to the prosecutor, you do you still want to represent yourself, or do you want to, you have a right to request time to either hire an attorney, or you can request a court-appointed attorney? Huh?
I don't want no attorney.
Okay, you don't want no attorney, okay. So you want to represent yourself? Okay, no problem. Now, let me, this document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature online that's titled
Yes, sir.
defendant? Or these your initials online that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You recognize this document?
Yes, sir.
And is this your signature online that's titled defendant? Now, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes.
Okay. Now, Mr. Jones, let me do this. I need to ask you some questions. Okay. Now, Mr. Jones, pursuant to the case of Ferretta versus California, 422 United States Supreme Court, 806, I need to ask you these questions. Now, have you ever studied law? Have you ever studied law? Have you ever represented yourself in a criminal action?
No, sir.
Do you understand the charges against you? You do?
They say, sir.
And this is a Class A misdemeanor, so you're aware of the maximum penalty range? Okay. Do you realize that if you are found guilty, you can be charged with or punished anywhere within that penalty range?
Oh.
Okay. Do you realize that if you represent yourself, you're totally on your own? Okay. As a judge, I cannot tell you how you should try your case or even advise you as to how to try your case.
Okay.
I cannot help you in any way. Do you understand? Do you understand that?
Repeat that.
Okay. Do you realize that if you represent yourself, you're on your own? As a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence in Texas case law? Okay. Do you realize that the Texas rules of evidence in Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. For example, how you should conduct a voir dire. Do you know how to conduct a voir dire examination?
No, sir, not really.
Okay. And do you know what are the grounds for excusing the juror for cause? Okay. And do you know what is hearsay? Hearsay, do you know what hearsay is?
Hearsay?
Yes,
Yeah, he say, she say,
okay,
correct,
well,
not,
are you familiar with some of the exceptions to hearsay? All of these are rules,
rules and regulations.
yeah, we have rules of evidence. Okay, and these are rules. My question to you, are you familiar with, the exceptions to hearsay? All right. Do you know what, the proper ground for impeaching a witness? Do you know when character evidence is allowed in court, in trials?
No, sir.
Do you know when and how to make proper objections?
No, not much.
Okay. Do you know when and how to move for a directed verdict? Okay. Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for mistrial? Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court? Okay. Do you know how to request and object to jury instructions?
No.
Okay. Are you familiar with the Texas Rules of Criminal Procedure? Okay. Do you realize that those rules govern the way in which a criminal case is tried in court? Do you know that? All right. Now, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law, you're not familiar with the court procedures, you're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you're found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney? Okay?
Yes, sir.
Now, is your decision entirely voluntarily on your part?
No.
Okay. Let's see, he needs to fill out an affidavit. If he doesn't have one filled out.
I did. I feel something, I don't think I feel it out. Right.
Did Bill, I don't think, what's the last name?
Jones, he didn't know. The only thing I have is these two right here. Just, yeah, he can have a seat at that table.
Right.
The whole thing?
Yeah, the first page and top of the, bottom, second page. And if he qualifies, John, we gotta do John Mason. It was John Mason,
Let me get that so I can change it, Judge.
huh?
Let me get the affidavit. I mean, not the
This here?
affidavit, the.
Yeah. You have any bond forfeitures? He can have a seat.
Yeah, I am. I just wanted to show
Okay.
them what you're doing this.
And it'll be John Mason. Who bond forfeitures, is it
Make sure you tell.
who is it? That's,
You don't want?
Well, check.
what
How
about,
much I get a month?
Yeah.
did Michelle Miller show up? Michelle Miller,
That's the one when she hired mine.
okay. You talking about Rodriguez? Romero Rodriguez.
Oh, you know, look, it says projected release of the to November, so we just. check this out.
Okay, next case is John Keith Simeon. John Simeon was scheduled to be in court this morning at 9 a.m. At about 9 a.m. Court's bailiff called the name of John Simeon at the courthouse door. John Simeon did not answer. A reasonable time has passed to give Mr. Simeon an opportunity to appear in court. He has not appeared in court. State, do you have a motion? Okay. And you can call his name again.
It's confused, I wasn't ready for it. My God. Right, that's time to make it to the bench.
John Simeon. Please call the name of John Simeon. The time is 12:11. Okay. John Simeon's name was just called again at the courthouse door. John Simeon did not answer. The time is 12:11 on today's date of May 6th of 2025. John Simeon did not answer. State, do you have a motion?
Mr. Walker.
That motion will be granted. John Simeon's bond will be forfeited and warrant should be issued for his arrest and cause number 23 CCCR 1050. Next case. Did we? Washington, she was reset. What about Jacqueline Young? Okay.
Yes.
Okay, well, this will conclude the calling of the court's docket on today's date, May 6, 2025, County Court at Law number 2, Jefferson County, Texas, Judge Terrence Holmes presiding. Everyone, please have a blessed day.